Okay, welcome everybody. Thank you for the brief hold while we got folks dialed in and settled here in the room. I'd like to welcome everybody to the Energy Bar Association Energizer titled Legal Perspectives on NERC Cybersecurity Supply Chain Risk Management Standard. Certainly a mouthful. We have a few experts here today who will help you understand not just the final rule and the standard itself, but some of the issues that lawyers in-house and outside are seeing today. So just before we get started, the format for the discussion is really just a moderated discussion. If at any time during the presentations you have a question and you want us to back up or explain a term on the page or something in the slides that may not have enough detail, please just interrupt us. We'll stop and pull up, because if you have the question, somebody else probably does too. So, you know, if you have a question, just feel free to save it till the end, or if you want to bring it up in the middle before we move on, that's fine too. We are going to keep the line unmuted the entire time to promote the discussion, so if you are calling in, just be sure your line is on mute in case you do want to multitask or you have, lunch yourself in late afternoon. Just before we get started, I want to introduce our speakers. My name is Bill Edwards. I'm an Assistant General Counsel with Exelon Corporation, primarily focused on NERC reliability standard compliance. I support all 6 Exelon utility companies, as well as Exelon Generation, which includes both fossil and nuclear and renewables. So it's a pretty broad scope of internal clients. We also have today Paul Ackerman, who's our lead compliance counsel for reliability and cybersecurity at Exelon and all of its operating companies. He handles compliance investigations, enforcement defense, regulatory advocacy, and transactional support for Exelon. He also advises senior executives in the development, direction, and oversight of compliance, cyber, and physical security. So welcome, Paul. Dan Skies is our second presenter, also our host today. Thank you, Dan, for hosting us here at Morgan Lewis. Dan represents electric utilities before FERC and other agencies on rate, regulatory, and transactional matters. He handles rate and tariff proceedings, electric utility and holding company transactions, reliability standards development and compliance, and FERC rulemaking proceedings. You can pretty much assume if it's in energy, Dan can handle it sounds like. We also have our third speaker, Shami Elstein from NERC. He's a senior counsel with NERC. He's been handling cybersecurity since the SIP version 5 standards came to life, essentially. So we're happy to have him here to offer his expertise on the cybersecurity standard and on the supply chain and explain some of the ins and outs from the NERC perspective. So thank you first to all 3 panelists for joining us. I'll have some questions for you if the group does not, but otherwise we'll plan to run through presentations. If you have questions, please ask them. If there's silence, I'll fill the void with my voice and ask some of my own. So without further ado, just a couple housekeeping items around the Energy Bar Association. EBA has approximately 2,600 members and promotes the professional excellence and ethical integrity of its members in the practice, administration, and development of energy laws, regulations, and policies by providing educational programming, networking opportunities, and information resources. Our group here certainly came together partly as a result of the EBA's work. We're promoting this Energizer through their committee, so certainly this event is true to that mission statement. How does an EBA membership enrich you? You're provided discounted CLE for in-person online programming. You get access to federal and state regulatory officials who impact your clients, industry-relevant content, inclusion in the membership directory, access to Law Journal, among other benefits. There's a hyperlink in the presentation materials if you want to visit EBA's site and navigate and see what benefits are out there. If you're not a member, we encourage you to join. There's also a calendar of events at ebanet.org where you can find more information about upcoming events, including this one. I'll mention that there's another panel on cybersecurity-related rulemakings that's coming up in 2 weeks from another committee. Some of the supply chain topic will be covered there as well, but they'll also speak more broadly to things happening in cybersecurity, and they have some subject matter experts as well to offer. Just a reminder, too, you can connect with EBA on LinkedIn and Twitter for news and upcoming events. again, we mentioned Morgan Lewis, but thank you again for hosting us. This is the second Energizer like this where you've been kind enough to host an event organized by Paul and myself. And we also like to thank the EBA System Reliability Planning and Security Committee for sponsoring the topic as one of their promoted items as well. So thank you to both groups. And with that, I'll turn it over to Shami Elstein, who's going to give you an overview of the reliability standard. And just to take a step back, the presentations we're going to provide to you, Shami's going to cover the standard itself, some of the nuts and bolts of what the requirements are, and the history of how it came to be. Then I'll turn it over to Paul, who's going to speak about the final rule, some of the changes that FERC directed to the standard, and then speak about some of the industry efforts that are currently going on to actually implement the standard. And lastly, I'll turn it over to Dan Skees to talk about how outside counsel is supporting the supply chain implementation for their internal clients, and hopefully he can give you a sense of where you can also be reaching out and helping your own clients. And he'll talk about some of the ways that he's advising clients and how those clients are reaching out to him. So with that, I'll turn it over to Shami.
Yeah, thanks, Bill. I'm going to get started talking about the standard, and if I'm talking with terms that are not familiar to you, just interrupt me and I can explain them. I'm often talking to audiences that are familiar with the standard, so I'll try to explain, but if not, don't hesitate to interrupt. The standard came about through a FERC directive to NERC to develop a standard that addresses supply chain risk management. I can't speak for FERC, but it was one of the areas that if you matched up the NERC SIP standards, the cybersecurity standards, and NIST standards, it was one of the areas that wasn't specifically addressed. So it seemed to me that they were trying to kind of match that up to say, what are the big areas in cybersecurity, and are NERC standards not covering each thing. So supply chain was on some level addressed in our other SIP standards by the controls you had to have, but it wasn't directly addressed. There was no plans or processes or controls you had to have that were specific to supply chain. So following the order, it was order number 829, NERC developed a new standard, SIP 13, and made modifications in SIP standard 5 and SIP 10. The standards focus on the 4 security objectives of software integrity and authenticity, vendor remote access protections, information system planning, and vendor risk management and procurement controls. And these were the 4 objectives that were listed in the FERC order. And I'll explain these as we go on. In general, the standards are trying to mandate that entities have processes to deal with certain risks out there. Risks that you're going to contract with a vendor that doesn't have the best practices. Risks that you'll procure an unsecure product, right? Something happens in the supply chain that the products you're getting is counterfeit and won't work, or has malicious code embedded in it. So these are the types of things that the standard is trying to get to. But the standard is limited in some ways, as is NERC's jurisdiction over vendors and suppliers. And entities, our regulated entities, have a much different sizes, characteristics, what they do. And so given all of these different factors, right, the differences in the diversity of environments that entities have, the standard is focused on process. What steps is an entity taking when it's going to plan and procure its cyber systems that help control and operate the grid? What are they doing to account for security issues? There's no one-size-fits-all protections here. The standard is, and I'll get to the language of the standard soon, but there's no specific controls. This is about process. What are you doing? We want to mandate that you're going to take into account security issues when you're going to procure cyber systems that are going to control the grid. And so it's about creating a structure or a framework within your organization that says we need to assess these risks, identify them, and make informed decisions about who we contract with and what we're contracting for, what we're acquiring. And you'll hear this from me a lot, and I'm sure the other presenters will as well. there is a lot of flexibility in the standard as to what entities can do. And it's really up to the organization to develop the controls and the processes that suit their needs. NERC is not dictating one set of outcomes over another. So there are two basic obligations. There are three requirements in the standard, but there are two basic obligations that override everything. The first is to identify and assess security risks when you're planning for BES cyber systems. Up there, I mentioned high and medium impact BES cyber systems. For those that aren't familiar with NERC SIP standards, when an entity goes to identify the systems that it needs to protect, it has to categorize them as high, medium, or low. Obviously, if it's high, those are in your big control centers. For instance, if you're an ISO or RTO, you're operating the grid on behalf of the transmission owners, you're going to have a lot of high cyber systems. In fact, all of your cyber systems in your control centers will be high. The next level is medium for your bigger substations, et cetera, and then your lows are a lot your smaller generation facilities, your smaller substations. And the protections applied to these systems depending on how you rank them, how you categorize them. So these standards the supply chain standard, at least SIP 13, only applies to the high and medium. The idea is to focus on the highest risk items. And the purpose of this assessment or identification of cybersecurity risks is to help the organization or force them into making informed decisions. The language of the standard actually doesn't say what you need to do once you identify and assess the risks. Given that there's so much diversity in the industry, didn't feel it was appropriate necessarily to mandate what you can do, but the standard's going to force you to make an informed decision. It's going to force you to document how you've assessed the risks, how you've identified them, and then it's up to the company to make a business decision. The second step of SIP 13, the standard requires you to include specific security concepts within your procurement activities, right? So when you're going out for an RFP or you're negotiating a contract, there are certain items the standards require you to consider. They include vendor security event notification processes. If the vendor is having an issue, right, we want our entities to know that, right? So if they've had a breach, we want them to notify the entity so that the entity can take mitigating action. Another one is coordinated incident response, right? Same thing, not just the notification, but how are you coordinating your response to a breach or an attack and so forth. Vulnerability disclosures. If they've uncovered a vulnerability in a product that you've purchased, they should notify you, right? And the idea is to try to get them in the contract for them to notify you of these types of things. And there are others as well, but I won't go through the whole list. And again, the focus is on process here, not outcome. The standard does not require the entity to get each of these things in their contract. And that was a big sticking point in the development of the standard, and I'll talk through that a little bit later. But I think it's important to know that this is about how the entity is looking at its risks, how it's judging what it wants in the contract, what are its must-haves from a security perspective, what are the things it could kind of live without to get the product at a reasonable price. NERC is not trying to override the business needs here to get stuff at a low cost, but that requirement, just like I said earlier, is what steps have you taken in your negotiations, in your RFPs, right, to include these types of concepts? The hope is that the vendors respond when an entire industry is asking for these things, and they start to provide these things as a matter of course. But the outcome is not what we're looking at. It is the process you've implemented. I'm going to go through some key sticking points. Let me stop here and ask if there are any questions about kind of SIP 13's main requirements that I just went through. If you have any, I can. Seeing none, I'll just continue to move on. I do want to discuss some of the key sticking points that occurred during development because you kind of see it in the standard and the way it's drafted. The first thing is that NERC has limited jurisdiction under 215. It applies to users, owners, and operators of the bulk electric system. NERC cannot enforce standards against vendors, suppliers, resellers. If they don't use or operate or own bulk electric system assets, that's it. We can't touch them. And so there's limits to the effectiveness of our standard, how far it can reach. We can reach to our registered entities, those users, owners, and operators. And we know that they'll have to work it out from a business angle in their contract negotiations, et cetera, how to hold the vendors responsible for what security concepts or security provisions they've agreed to.
And just to highlight some of that language you just used, the users, owners, and operators, that's coming directly from the Federal Power Act itself, correct?
Correct.
Okay.
Yeah. And the second thing I've already mentioned is that it only applies to high and medium impact BES cyber systems. There was a long debate during the development as to whether it should also apply to loads. Now, loads, in fact, make up a huge portion of the cyber systems that are helping to run the grid, but they are lower risk. And ultimately, in the first stage of this, if there isn't even other stages, I'll get to that in a second, the idea was to focus on those higher risk assets. Another thing that was not covered in the standard were those other types of cyber systems, like a printer on the same network as a BES cyber system, as your SCADA system, or your firewall that protects access into, when you set up a protection, a logical boundary, you have firewalls or other devices that control electronic access. And those are not covered by the standard either. Although I'll get to it in a minute, FERC has ordered us to put those in, and I'll explain that a bit. So it's very limited what assets are subject to the standard. It applies to interactions with vendors. One of the big debate was, what is a vendor? Who are we contracting with? When we have to have a process for identifying the risks and for negotiating these types of security provisions, who are we? When does the standard apply? Right? Who are the types of folks we need to implement this process for? And the short answer is almost everybody. Right? If you're purchasing or acquiring services for a BES cyber system, you're working with a vendor under the standard. Your resellers, your product suppliers, your manufacturers, but it is only the people that you are in privity of contract with. We are not saying you need to reach down the chain and try to, work with these people. That just doesn't work that way. You can only deal with the people that you can only negotiate with the people you're in privity of contract. That said, when you're identifying risks in that first step of SIP 13, you should be considering that supply chain. Where is it being manufactured? How many hands is it passing through? Those are before it gets to the person you're in privity of contract. We want to know. We want the entities to be informed of that. Then there's limits to your knowledge, of course, where the product is ultimately coming from. But the more you can make an informed decision about who to buy from and what to buy, the better. And again, it's a forward-looking standard. This is directly from the FERC order. They're not asking you to go back to your contracts that you've already had, that you've already negotiated. So it does not require you to renegotiate. It's not abrogating existing contracts. It's only for the contracts looking forward. So after the standard becomes effective, looking forward, you have to implement your process. People have also asked, what happens if I'm in the middle of negotiating a contract? Terms aren't yet set, the effective date happens. NERC is not going to look at that because you're in the middle of your process. We're not going to ask you to go back and then implement your process. We hope that, as the implementation of SIP 13 gets closer, the effective date, that you begin to have those things in your process. But if you're in the middle, you're not going to have to go back and restart your process of negotiation. We're really just trying to look forward. And I think this was probably the main sticking point, and I know Paul actually got on some calls and helped us with some language here for the standard. But when I said earlier that we're focused on process, not outcome, the actual terms of the contract are outside the scope. When a NERC auditor comes in, or or your regional auditor comes in to look at what you've done to implement your process, they are not going to look at your contract and say, well, you don't have vendor security notification in here, right? That's not what this standard is about, because there's different purchasing power and bargaining power amongst our registered entities, and so we left that outside the scope of our standard. Now, as evidence of what you've got, you can obviously show the auditor the contract to say, look, I implemented my process and I was successful in getting this. We want to look at the process. What did you do in good faith to identify the concerns and try to get these types of security provisions in your contract? And I have the text here of the standard for your viewing pleasure, and in 1.2 are all the list of things that we want you to involve or incorporate into your contracting process. And one thing that I didn't mention yet, there are two other requirements. So everything I mentioned so far is about R1, which is requirement number 1. There are two other requirements. So the second requirement just says implement the plan that you were requiring you to have in the first requirement, and then it has a note about not abrogating existing contracts, and the actual terms and conditions are not in scope. And I left out vendor performance. In addition to not looking at the terms of your contract, NERC's also not going to be in the business of looking about how well your vendor is performing under the contract. That's going to be an issue, a business issue for you guys to enforce. There are a lot of factors that go into a company's decision as to how to, enforce its own contract if the other party's in breach, and NERC wants to stay out of that. And then requirement 3, which is just below on the same page, every 15 months we want the company to do a review of the process that you've implemented, make improvements, make changes as necessary.
Just to go back to requirement 1 for a second. So obviously the requirement, sets forth the expectation to have the process in place for high and medium impact, and then lists out the mandatory inclusions in that process. Can you talk a little bit to if entities put in processes or the criteria beyond what's listed there, how will NERC treat those as far as being above and beyond the standard or, subject to enforcement?
Yeah, I think from a compliance perspective, if you're doing things above and beyond the standard and you don't necessarily do them according to your plan, that's not something. We're only going to audit to the language of the standard. That said, when we look at a company who's going above and beyond, that shows a culture of compliance. It shows the interest in really dealing with those issues. So I think you get, I don't want to call them brownie points, but we look upon that favorably, right? I mean, you see a company that's making that good faith effort. It's going beyond just the letter of the standard, and that kind of gets you places.
Can I make just one point on that? This is one of those standards, sort of deceptively simple, but you develop your own program, you develop your risk assessment process, and then you implement it. If you develop that process and it includes more than the minimum requirements, you need to be very careful on how you draft it, because the way this is worded, and I've seen auditors actually do this, it basically is saying you've got to at least have these 6 elements in it. If you add 4 more, it is a positive step. But you need to be clear in your documentation that you're doing that as above and beyond compliance, so that you don't back yourself into a compliance issue for perhaps not following your policy on one of those additional issues. The other thing is you need to be careful just in how you lay out the policy, because if the policy requires you to go through certain steps to actually address these issues, if you don't go through those steps, you have implemented your policy. So in a lot of ways, you're setting yourself up for how you'll be measured by developing it. So.
Yeah, that's a great point. I mean, before I worked at NERC, I also worked at law firms, and we used to draft policies for clients, and the first question we'd always ask is, can you do this? Right? Because the worst thing is having a policy that you can't do, right? And you really need to make sure that if you're advising your clients or if you're drafting it for yourself, that the steps are doable and you follow them. I mean, the standard, as you saw, is pretty open. It's not prescriptive, right? You can develop, as long as you're meeting the objectives, your process can say, everyone's process can be a lot different. So it's important to be able to develop a process that you can do effectively.
So just to highlight one of the things we're really talking about today, how as outside counsel or inside counsel can you help your company, that's exactly one of those situations. When you have the process developed, how do you take the security goals that you're trying to balance them with compliance risk, and what does the language in your policy? So that's something that legal counsel should be involved in reviewing.
All right. The other standards that were modified as part of the supply chain risk management proceeding were SIP 10 and SIP 5. So if you think of SIP 13 as your planning and procurement phase, SIP 10 and SIP 5 add some specific requirements in the operational phase. And they relate to software authenticity and integrity. And SIP 5, which I'll get to in a minute, relates to vendor remote access. SIP 10 requires entities to verify the source and the software source and the integrity of the software obtained by the software source. It's a little bit redundant, but essentially, when you're getting updates to your software, right, when you're getting new software, you have to make sure it's coming from the right place, right? That's part of your supply chain. You don't want to get counterfeit software. You don't want to get software that's been changed and modified in any way that the source of it, like the company you're contracting with, didn't know about. And it works in tandem with a requirement in SIP 13. So SIP 13, one of the list of things you have to include in your procurement process is software integrity and authenticity, and coordinating how you get patches and how you get the new software. And if you can do that, it makes this a lot easier. So this is before you install anything, make sure that it's coming from the right source and it's good. And again, this is not very prescriptive. How you do it is not mandated by the standard, but you have to do something. You have to show that what you've done, what you've put together, is sufficient. Here's the text of SIP 10. It's part 1.6. Fairly straightforward, but obviously more complicated in application. SIP 5 relates to vendor remote access. So most, if not all, systems that you procure from a vendor often require maintenance by that vendor, which often requires them, and other things, it also requires them to be able to remote into that system to fix. And one of the issues is if that remote access is compromised in any way, that could allow an attacker to get into your systems unfettered. And so what this requirement does, with the new additions in Part 2.4 and 2.5 of SIP 5 is intended to do, is to say you must be aware of all the active remote vendor sessions that are going on. So if a vendor's in your system remoting in, you have to have a process to be aware of that, right? And you have to have a process to disable that. Why? Because if you see anything funky going on, technical term, you can cut it off right there. This is, I don't know if people are familiar with some of the attacks that happened in Ukraine several years back, but if I'm remembering correctly, what they did was they got passwords, right, that they got through phishing attacks, and they used those passwords to remote into the system and take over control, operational control. And so one of the things that we want to make sure is that if a vendor is compromised and they can remote into your system, that you're aware of that it's happening, and if anything suspicious is going on, you can immediately terminate it. Before that wasn't a requirement in the standards. That this kind of fills, it satisfies that ability. One thing to note here is that it includes system-to-system access. All the other NERC standards related to remote access deal with user-initiated access. So I'm sitting at a computer somewhere else, maybe in a Starbucks, probably shouldn't allow that, but I'm remoting into a system. I'm user-initiated. But there's also a lot of systems that talk to each other. And so in these requirements, we're including system-to-system. So you have to know when your systems are talking to each other, and a system in your control center, for instance, is talking to a system outside to pull data or anything else, we want to make sure that that is not compromised either. So if you see something suspicious going on, you'll have to terminate that as well. And that's the basics of our requirements for the supply chain risk management. I'll pause here for some questions, if we have any, before I move on to some of the other activities NERC is doing before I turn it over to Paul. All right.
I have a quick question.
Yep, go ahead.
You said that it's looking forward relative to the contracts. What about if you have a master services agreement with a supplier, for instance?
Yeah, that's a very good question, because you have a master service agreement, you just keep on, you have different, sometimes you have different SOWs under that, but you're kind of procuring the same product. And I believe that, and I think we put this in the petition as well, that those agreements would not require you to renegotiate. I think that's too disruptive to the business. While we certainly encourage entities to rethink some of those older contracts and what kind of security provisions they might want to include going forward, there's not going to be an expectation that you have to do away with those master services agreements or somehow renegotiate into your new statements of work or what you're procuring under those services agreements. From my perspective, though, once you start to open those up for different negotiation or different provisions, other than maybe small pricing changes based on commercial matters, then I think that there would be an expectation that when you reset, you would look into those contracts to apply your SIP 13 process.
Yeah, it's a really good question, and I think part of our company's implementation is needing to identify renewal dates so that we know when things are coming up and what renewals are going to come into scope. So it's an important aspect of this.
Okay. All right. Just quick. NERC has a process, what we call our compliance guidance or implementation guidance process, that allows our registered entities, certain select groups like your trade associations and other types of organizations can come in, and it can be drafted by anybody, but there are certain pre-approved companies or organizations that can come in with implementation guidance to say, hey, NERC, here's an approach for complying with this standard. And then NERC will review it and endorse it if it agrees with the approach, that they think that the approach would lead to compliance. It is similar to anybody who's familiar with FERC's no-action letter process, where you can go into FERC staff and say, given this set of facts and circumstances, would you recommend an enforcement action against it? It's similar, it's not the same, but it is a way for entities to develop a compliance approach and put it out there, and it has some presidential value if the same set of facts are repeated elsewhere, right? But it gives industry kind of an awareness of how NERC is viewing compliance. The standard drafting team that worked on the SIP 13 standard also drafted a compliance guidance or an implementation guidance that was endorsed by NERC. I encourage everybody to read it. You can find it on NERC's website, hopefully in under 3 clicks, but I may doubt that. But the one thing I wanted to point out is that implementation guidance encourages entities, and it's endorsed by NERC, to take a risk-based approach to developing their plans and processes. Now, what I mean by that is that not all your products are created equal. Not all your vendors are going to be created equal, right? And don't just have a process that treats them all the same. It's going to eat up your resources, right? I mean, you shouldn't be applying the same type of attention to your SCADA and your relays as your more minor systems that help you run, right? I mean, we encourage us to think through we know you have limited resources, right? So think through your processes to apply the protections and your resources where they're most important. That doesn't mean ignore the lower things, but be cognizant of that. Also dealing with sometimes you're going to be dealing with vendors that are maybe one-offs, that aren't as well known. Look into those greater than you would be the titans of industry, right? I mean, you kind of who may be able to show you some pretty robust security plans in their supply chain. There's also NATF, I believe, also drafted one for SIP 13, and they drafted one for SIP 10 that has various approaches for verifying the software authenticity and integrity. So I encourage everybody to look at those. When the NERC board passed the standard, they approved the standard to then file with FERC and other applicable governmental authorities. They had some questions. And they really, around two items. The first was an acknowledgement of our limited jurisdiction. And they understood that in a complex environment, it's a global supply chain, that NERC standard applying just to users, owners, and operators aren't going to solve the problem. And so one of the things the board directed NERC to do was look at what other tools we have to help, right? And they also, on the second part, they also looked at the standard and they say, okay, we see no loads, we see no what we call electronic access and monitoring systems, or EACMS, which are like your firewalls, like I mentioned. We see no PCAs or protected cyber assets, which are your printers or other types of devices that are on the same network as your cyber systems that are also deserving protections. And we also don't see in the standard your physical access control systems. The SIP standards require you to have physical access controls, and some of them are electronic, right? Every morning, I'm sure most of us buzz into our doors with our key cards, and that is a form of a physical access control system. And so what the NERC board says, we also want to look at these risks. That we are approving this standard because we think it's an improvement to our standards, but we also want to look at other supply chain risks to see if our standards should be broadened, or is it the right scope at this point. And so they have, and we also want to make sure that the standard's effective, right? And they issued a series of resolutions. I've listed some here. So support effective and efficient implementation, do a supply chain risk study to see about the scope and what other risks are left on the table, and kind of what other things, right? For forum and association white papers, they asked the NATF, the NAGF, APPA, and NRECA to draft best practices, especially for the smaller entities who may not be as have as large as procurement teams as some of the bigger companies. And then eventually they want us to evaluate the supply chain standards. So I'll just briefly describe a little bit of what NERC is doing on each of these items. So for effective and efficient implementation, NERC has a pretty good web page just about our supply chain standards and things that are going on. Encourage everybody to check it out. I should have actually included the link, but I don't have it down, but I'm sure it's pretty easy to find it. Our CIPC, or our Critical Infrastructure Protection Committee, which is a standing committee of the NERC board made up of interested stakeholders. They're doing a lot of work on this. They're doing some work to support implementation by maybe drafting some guidelines. They're doing a lot of webinars and workshops, and they're also helping us document risks for those eventual guidelines. NERC and the regions are also doing what we're calling small group advisory sessions, and they did this for the other SIP standards during the transition to version 5. And these, I think, we've gotten a lot of good feedback. What it allows is entities to come in, meet with NERC staff and FERC staff, and a lot of them are compliance staff, and go over the standard and what it would take to comply. Right? This is kind of before the effective date. So as companies are thinking of how they're going to implement, they have an opportunity to meet in a small group, either alone or with some other entities if they don't want to do it like that. And they've already started this. I don't know the dates, but if you look on the standards webpage, You can find them where they're going around the country to different regions, and they're having these small groups, and you can come and talk. And I believe that the entities who have participated in this have found it quite helpful. And they're doing other outreach and readiness evaluations. The supply chain risk study, the board approved the standard in September. No, they approved it in February, I believe, of 2018. And they said, 17? Whatever, I don't remember, August. And they said, come back in a year with an interim study on the risks and the scope of our standard, and then in 18 months, come back with the final report. So in September of this past year, we had an interim report done by EPRI, which is the Electric Power Research Institute. And they did a good study of identifying, they looked at the market for the items that entities buy for their systems, and they looked at risk, they looked at what our standards covered, and we're taking that now, and we are turning it into a final report for our board this February. So look forward to that report. Depending on what it says, could be partly redacted, but I think we're going to make it all public. I don't think there's anything really confidential that's going to be in there, but just a warning there. Communicate supply chain risks. This is where our electricity sharing and information sharing and analysis center comes into play. The ISAC, I don't know if many of you are familiar with that, but they are really important sharing information. So they're also focusing on supply chain and developing guidelines and other alerts for industry to keep aware of those things. Lastly, forum and association white papers. Both NRECA and APPA have developed white papers, really best practices on supply chain, and they should be posted. And so I encourage everybody to look at those, not just the entities who are part of those trade associations. And lastly, the plan to evaluate the effectiveness. In the next few months, NERC is going to put its head together and think about ways to measure the effectiveness of the standard. It's going to be a tall challenge for us, given that trying to measure the effectiveness of the standard on a global supply chain is going to be difficult. But if we can take off small chunks, we may be effective in that. And I think really what we want to see is how is the standard changing, not the global supply chains, but at least the behavior of entities and the manner in which they approach the planning and procurement of their BES cyber systems. That's all I have. I forget if one of you are just going to discuss the FERC order. I'll leave that to you. But I'll take any questions, or we can move on.
Sure, I have one, and we'll open up to the phone in the room. But just quickly before we move to Paul, what's the reaction been, if any, from vendors? I don't know if anybody's reached out directly to NERC or participated. But I guess question for Shami and any of the other presenters as well. What have you heard from vendors about the standard thus far?
We've gotten actually good reaction at our SIPC, for instance, that I mentioned, and in other areas. Vendors are actually, especially the vendors that are specific to the energy industry, actually coming and saying, hey, let's discuss, right? Because they have an interest, I believe, in not having to field, these questions from entities over and over again. And if they can standardize what they offer security-wise, it behooves them to do so, right? Because it makes their process easier. So they're starting to get engaged in the conversation. Some of the bigger ones, not necessarily, right? Because they don't,
They have their ways.
They have their ways.
They have their own rules.
So you are seeing engagement from the vendor community. How it actually works, I think it's a little too early to tell because the order was only issued a few months ago, and you have until July 2020 to implement, which Paul will get to. But you are starting to see them engage, and I know that a lot of the entities are also starting to engage them as well. I know that it was a board meeting, a NERC board meeting in a few months ago, I think it was maybe it was May, where some folks from industry were presenting on ideas to work with vendors to make this an easier process for entities to implement. So I know that they're coming to us, and I know that entities are going to them to make it simpler, I guess, and more uniform.
Thanks. Any questions here in the room or on the phone? Yes, one at the end.
Yeah, so I might have missed this. I stepped out for a call, but we've been getting questions from our clients about what kind of vendors the rule applies to. For example, we had a client ask us, does this apply to our contract with you as a law firm? Do you have any?
Yeah, so it is about who's supplying you your VES cyber systems, those systems that are being operated, and who's providing you services on those systems. So it's not just the procurement of the system, but it could be, whatever services someone is using. This is not about all of an entity's contract. So while we interpret vendor broad, the term vendor broadly to include anyone who's kind of doing this, if a vendor is not doing something related to those systems, you don't have to involve them in your process. So if they're just selling you stuff that you're putting on your corporate network, you don't have to have your process for that, your SIP 13 process for that. But they're selling you your laptops that are only going to be on your corporate network. You don't have to do that. Now, a lot of companies I heard say, well, we don't know where it's going to go, so we're going to apply this process anyway because it may end up in our operational environment, it may not. So the company has to judge how it wants to do that. Other companies have said, no, we're now going to completely separate those processes. Now, I imagine when they're buying laptops for their corporate systems, they're still going to go through some sort of security protocols there as well. But some people from a compliance perspective want to make sure there's a distinction between my operational sphere and what I'm going to apply this process to and what I'm going to apply my other corporate processes.
Guys, a few quick questions. Very simply, one, when does this become enforced? When does it start being enforced? Yeah.
July 1st, 2020.
July 1st, 2020. What was the genesis of designing this, building this? Like, what was the objective? And what is the relationship? How is the insurance industry responding?
I can answer the first question. I can't answer the second question because I don't know the answer. The first question, it came from a director from FERC, kind of complete kind of what our cybersecurity standards cover.
Yeah.
And then there were, demonstrated events that occurred because of lapses in the supply chain.
Yeah.
And so that was, when you looked at NERC standards, there wasn't something specific to supply chain.
Yeah.
There were events that are occurring maybe outside the energy industry, but there were a couple, I think, even in the energy industry that didn't have any significant impact in terms of what happened during the event, but there were vulnerabilities exposed. And so the attempt was to get something in our standards to help mitigate that risk. And I say mitigate and not solve because I don't think we believe it's something that could be completely mitigated by just applying requirements on owners, operators, and users of the VPS. But the more entities do, the more informed decisions they make, the better security you'll have.
I have a question. So with regards to the vendor contract agreements, contractual agreements, so you said that the standard only applies to contracts when the operator is in privity with the contractor, so it doesn't slow down the second and third tier subcontractors, correct? Is that a correct assessment?
Yeah, well, let me make a distinction. So what I was referring to is an entity is buying product A from a vendor. That vendor may be getting it from somewhere else.
Correct.
Right? And so we're not expecting the entity to reach behind behind the vendor they're contracting with.
So there's no flow down contractual requirement with regards to the supply chain risk assessment?
The hope is that when you're picking vendors, right, in your vendor selection, you're considering the risks of that chain.
Sure. So I guess my question is, Is the expectation that eventually, like, the subcontractors will include these, like, new assessments and they'll just slow down, like, sort of like the DOD FAR regs, the DFARS regs, right? So it's the same concept, except for they actually require the sub. It actually goes down to, like, the second and third tier sub, but they have to adopt those same cybersecurity requirements. So it's the expectation that we're not going to make you guys pass down these requirements to your sub-vendors, but eventually they'll just pass them down contractually? I'm just trying to understand.
I think the hope is that by starting here, it all flows.
Okay.
And of course, the entity who's purchasing something or a service could say, we want to make sure that where you're getting it from also, right? You guys do have some ability to slow down, but the standard is not talking about that second level.
Okay.
Now, I think that's a little bit different than saying, I'm hiring you to do a service and you can subcontract someone to help provide that service. At that point, I think there is some sort of, if there's that type of arrangement, then I think there is an expectation that, that's going to flow back. But in terms of the supply chain where it's manufactured in countrywide, flows through a few hands that add various parts and it comes to you through your vendor, that we're not asking, like, you're not to go through that supply chain.
Okay, I do want to get moving just because we are a bit behind on time. So just time check, we have about 35 minutes left. So presenters, just keep that in mind as you move forward and hit key points. But with no delay, we'll turn it over to Paul to talk a little bit about the final rule.
Yeah, thanks, Bill. Basically, I was going to cover two aspects. One, the actual final rule that implemented this, which came out October 18th. It's FERC Order 850. My slides on 850 actually cover a lot of the same ground as Shami presented, but I went ahead and left it in there because it's just another take and another resource for you all to use in briefing this internally. But what I wanted to focus on are the actual changes that occurred from when the rule was proposed last January and now. Just talk a little bit about that and talk about the implementation. Talk a little bit about my take on the new requirements, particularly the flexibility and some of the questions that you've raised in terms of flow down to vendors. And where I really wanted to spend the meat of the time was talking about two resources that are out there for you. Shami mentioned one of them, the NATF guidance documents. There's actually two of them, which we're going to talk about, and EEI's cybersecurity law group is engaged in a process to develop standard industry terms and conditions or model conditions surrounding those R2 1 through 6 requirements, so that we can kind of get some consistency and at least have a starting point with negotiations. So we'll talk about that. In terms of Order 850, as Shami covered, it implemented SIP 13 and then the changes to SIP 5 and SIP 10. The changes which it adopted were to order that electronic access control and monitoring systems be brought into scope. So right now the scope is high and medium BES cyber systems. Now the devices that actually protect those systems, like firewalls, et cetera, we're going to be brought into scope. And the slide here talks about some of the risks to those and why FERC felt it was important to bring those into scope, and why the existing controls didn't really address those concerns. So essentially within 24 months, those are going to be coming into scope. Two other devices that are kind of on the target that FERC wants to look closer at: physical access control systems and another class of devices called protected cyber assets. And you can look up in the NERC glossary terms exactly what those are. The physical access controls are your key card entries, any devices that you're using to physically protect your physical security perimeter. And the protected cyber assets are devices inside your electronic security perimeter that are logically connected, like the printers mentioned. So those, again, you see the creep in terms of more devices already on the hook to come in.
And then, not to interrupt you too quickly, but to your question at the end, you want to be engaging their counsel to explain to you which systems those are, and help you identify which vendors flow from those equipment types. So even here, there's future changes coming. You have to struggle with the question of, do you deal with that now as you're standing through your process, or do you deal with that as a second wave once you've gotten through the first push? So
yeah, it's a really good point, Bill. I mean, we're going to be talking about some of the guidance documents, and some of the issues are scoping, like how do you strategy-wise, are you going to apply this, you know, enterprise-wide, or are you just going to focus on, you know, certain systems or certain vendors? And you got to keep in mind the fact that you're going to need to expand whatever you're doing to cover these additional assets. Implementation plan, we're successful, you know, in arguing that based on some of the coordination that it was going to take with vendors and with respect to 5 and 10, so 5 and 10 changes, you'll likely see some need for technology changes. What was a year implementation became an 18-month implementation. And if you do the calendar math on it, essentially comes out that the new standards, all 3 of them will become effective July 1, 2020. Okay, the scope of the new requirements is high and medium impact BES cyber systems. I think it's interesting if you read the order. There's really some aspirational language from NERC that's in there about it expecting that because of the way procurement happens in our industry, that these requirements will flow to low impact systems. That caused a lot of concern within our folks in terms, because we have literally, you know, thousands and thousands and thousands of lows, and it's a much more complicated issue. But, you know, and Shami kind of mentioned this, the problem with, you know, a large company like ours, you know, we're buying relays and servers in lots, and sometimes we really don't know, are they going to be put in a higher medium impact facility, or are they going to be in a distribution facility? So we're really having to face the issue of, you know, and these are fairly basic controls. When you look at the 6 requirements under 1.2, which are highlighted here that Shami went through, I mean, security, event, incident notification, vulnerability notification. These are things that are pretty basic to, you know, cybersecurity. And so, you know, do you limit, you take the trouble to actually carve out your high and medium impact vendors and really focus on them, or do you apply this as a more broad principle of supply chain cybersecurity? And I think all of us in the industry are kind of dealing with that. So the flexibility built into SIP 13, you know, I can remember back with the stakeholder meetings when this whole process started, there was huge concern over the fact that FERC really does not have jurisdiction over our vendors in this. So how could they be imposing something on us that we've got to impose on our vendors? There's no jurisdiction. The other fear that was out there was, if you work in the nuclear space, the NRC actually heavily regulates vendors. They have statutory authority to do that. And it's resulted in many instances in much higher costs, and some would argue stifling innovation, new technologies, because you basically have a regulatory process on top of, you know, of your procurement. And that, you know, so folks were really, you know, the industry was really, you know, geared up to prevent that from happening. And to a large extent, we were successful. And Shami and I were talking, it's a little bit of be careful what you ask for, because essentially this standard, I don't think you'll see another standard in all of NERC's, you know, reliability standards that has a note saying these issues are completely out. Your contractual arrangements, whether or not you negotiate terms, whether or not your vendor complies, is not a matter for, you know, inspection under R2. It's a very huge carve out. And that carve out led to the board resolutions that Shami talked about, the concern. What is the industry doing here? Is it effective? Will the implementation of this standard really edge up security. And you talk about some of the motivation behind this, but when you look at a lot of the data breaches in other industries, the supply chain was the vector of attack, whether it's target breach or others. I mean, there's a acknowledgement that this is a serious attack vector. So the sort of the eyes of the government are on us. Is this going to be effective? And so one of the objectives you'll see in the sort of some of the industry guidance, the terms and conditions project that I'm going to talk about in a few minutes, is to get ahead of that, show that we've implemented this and implemented in a certain extent above and beyond, and we're actually moving the needle on security, and directly to avoid more stringent regulation. You see where they're already expanding the scope of the assets, but really, avoid even, God forbid, legislation that would expand authority over the vendors. And so there's a real incentive from my perspective, and this is my personal perspective for industry to actually step up and implement this in a way that is going to address the concerns that were raised, even though the statutory authority may not be there to reach down to our vendors. We talked about the SIP 5 changes and the SIP 10 changes, so I won't go through those again. So let's talk about the trade association resources. The NATF, when they received, I guess, a board resolution, well, let me say, first of all, I'm going to talk about these two, but there are a host of efforts on going out there. I think you mentioned a few, EPRI, the Generation Trade Associations, APPA. A lot of folks are doing work in this area. I'm touching on these two because I was involved in them, and also I think they actually have some of the more important developments in this area. But the NATF guidance documents, there's two of them, and one of them, which was previously referred to as a white paper, is a cybersecurity supply chain risk management guidance. And this is not focused on SIP 13 compliance. It's a guidance document to help companies address the issue of cybersecurity supply chain risk management from a broader perspective. So it would be, in some ways an above and beyond, but it basically is trying to outline a general approach on what you would take. So it goes sort of above and beyond SIP 13 guidance. They also drafted a separate SIP 13 implementation guidance, which NERC has approved, and it's actually the second one is actually on the NERC website. But both of these documents are on NATF's public website, so you don't have to be a member of NATF to get them, and I'd encourage you all to take a look and download and read through them. But I'm going to give you just a brief overview of them. So the supply chain risk management guidance, the broader guidance, is focused on a general strategy, what it means to actually apply risk management in this area. And as I said, it goes above and beyond SIP compliance. Four concepts in it that I wanted to focus on deal with what's listed here, the stakeholders that really should be involved in companies who are regulated by this standard or who are addressing this issue, the general risk process, and cybersecurity criteria and exceptions process. So when you're addressing this issue in your companies, one of the things we found was it goes well beyond the typical NERC grouping. You really need to bring in a broad section of folks. There's a lot of stakeholders, even within small companies, that are involved here. Obviously, the businesses that are procuring products, your cybersecurity professionals, whether they're in IT or within your security chain, IT folks, your supply chain folks, risk management, legal, and compliance, they all have a piece of this. And those folks need to be brought together, and that's one of the concepts that is talked about in the risk management guidance. Some of the considerations on risk management policy. I apologize, the first bullet actually is the header here. So risk management approach, and I think we talked a little bit about this, when you're approaching supply chain risk management, are you going to are you going to do it globally across all your IT and OT procurement, or are you going to focus on particular suppliers? Are you going to focus on particular asset types, or are you going to do something in between? So you need to kind of plot that out, and the guidance document talks about that. Any risk management process has got to begin with identifying risk areas and assessing them. And for example, in this instance with SIP 13, you have those 6 elements which we're going to come back to when we talk about the contract terms and conditions. But that essentially is identifying 6 risks. How are you going to assess those risks? Are you going to do vendor questionnaires? Are you going to rely on third-party assessment? So figuring out what's your process for assessment is going to be as important and also addressed in the guidance. And then tracking in-scope assets, so that you know that your risk management program is effective, and developing those security criteria. Are you going to just rely on the 6, or are you going to go above and beyond? And this is basically NATF is laid out. They actually have much more detailed depictions in their guidance, but essentially, let's take it from the perspective of the simple SIP 13 controls. You put those in the beginning. You assess through a vendor security questionnaire or through a third-party issues like does your contractor have an incident response program in place? And if they do, is there some indication that will be triggered and you'll be notified of an incident that affects the services or products that you're getting? So how are you controlling that risk? Is it with contract terms and conditions? Is it with vendor oversight, contract management? And then importantly, sort of how are you monitoring it? And that monitoring has got to come back around in terms of adjusting when there's change, when you have perhaps new contracts, new vendors coming in, or change of scope in contracts. You kind of got a sort of a life cycle. So the implementation guidance that NATF promulgated, that's the second document, is actually very short. It's sort of an add-on to the SIP 13 guidance that came out of the drafting team. But really, it was a stake in the ground to say that in implementing this, you can rely on your own program. You can also rely on an independent assessment of the vendors. And the hope here is that there are standards out there, industry standards that address some of the concerns in SIP 13. Those 6 issues, part of attachment B to the implementation guidance is actually a mapping to the NIST standards and other industry standards that actually address these issues. So to the extent that a third party is able to verify that, or I think ultimately the industry would love to see these issues go towards some type of certification. You can rely on that. This guidance, reinforces that. So attached to it are the criteria, and they're the limited 6 criteria. It also proposes some additional above and beyond criteria. So that's included in the guidance. And then, as I said, there's this cybersecurity framework mapping. And part of the work in bringing this together was actually to go out to some vendors and find out what industry standards were being used in this area. All right, the last and probably the most important from a legal perspective project that I wanted to talk about, and I've actually been involved in this, is EEI's cybersecurity law group is developed draft terms and conditions to address the SIP 13 R2, 1 through 6 issues that need to be addressed in your cybersecurity, your SIP 13 programs. And essentially, they're on track to publish these in the first quarter. If you are a member of EEI, you're allowed to join this group, and you'll participate in the process. The process now is in terms of the initial phase, in getting the initial documents out, we're almost to the end of it, but it's going to be a living document. There's going to be a process in place to get feedback, and it's essentially, model terms and conditions that, again, touch on those 6 areas. The strategy was sort of threefold. We wanted to help get something out there that could aid in compliance, but also, cite to use common industry practices like the NIST standards to develop some, reasonable approaches and flexible approaches to vendor compliance in these areas. And again, back to my initial point of, demonstrating progress, getting these into contracts so we can show that the industry is actually moving forward and improving security. So these last 2 slides actually give you a very brief description of each. These aren't the terms and conditions themselves. They're about probably 6 or 7 pages, and they're developed to basically be able to be plugged into your existing contract documents. It's not necessarily a separate exhibit. It's basically a common language that would address each of these areas. But just very, very quickly, event notification. We went beyond just saying you'll tell us when you have a security event, to actually say have an incident response or process that's in compliance with the NIST standards, and then when you report it to us, you need to report certain bits of information, and also allow us to coordinate with you on these. So it provides more detail than just what's in the standard. Again, vendor personnel termination, you'll see there's quite a bit of in there about developing policies and procedures, having the company retain control over access authorization to its facilities and equipment, and having the vendor periodically review the need for individuals to have access on their own. So vendor vulnerability disclosures, the software integrity, again, these try to incorporate NIST standards as a means to build some flexibility. And then at the end, we've also included some supporting provisions, audit rights and support for regulatory examinations and information protection provisions, much of which will, depending on how you use these, will cross-reference with your existing terms and conditions, and you'll need to harmonize it. But at least this provides sort of a basic framework for the industry to go forward with on these issues. So, any questions?
Thanks, Paul. So, just to highlight the things you've mentioned and the things that were referred to by Shami are all resources available out there. If you don't have access to those resources or you can't find them, obviously, turn to legal counsel for support as well, drafting contract terms and conditions and thinking about these things, which is a good segue into our next speaker. We want to give Dan some time. We may go over by a few minutes, and hopefully, folks in the room, if you need to go slower, we understand. But I think it's good to hear what he has to say and give you an opportunity for wrap-up questions. So,
hey, Bill, one thing I forgot to mention, the terms and conditions will be publicly posted as well. So regardless if you're an EEI member, you'll actually be able to have access to those on EEI's website sometime in the first quarter next year.
Great. Okay. With that, I'll turn it over to you, Dan.
All right. Thank you very much. So I'm going to provide a sort of a brief overview of what we think about and what we're starting to deal with from an outside counsel perspective. And I think a lot of this is driven by the fact that it's a weird standard, right? Traditionally, the SIP standards have certain security controls in place that meet a certain security objective, like password complexity or intrusion detection and physical access control. Here, we're talking about a regulation that sort of says, here's how you need to interact with outside vendors. And while it sort of generally sets up some objectives you need to achieve, they're not necessarily, quantitative and an easy way. And so it's a little bit different. That creates a lot of weird implementation issues that I think we'll see over the next 18 months as we get to close to implementation. When the standard was pending at FERC, I was a little concerned that, FERC staff might ultimately take a dim view because it's kind of bushy, right? It doesn't require a lot of really specific stuff, and it leaves a lot to the flexibility of the industry and to, the discretion of the industry, and then really to the discretion of the regulators when they come to audit it. And I think, ultimately NERC and the industry did a good job of developing a standard and selling the commission on, we understand the risk, here's how we think what is the best way to address it. And the commission, thankfully, accepted it. And I think one of the challenges for the industry and for NERC in the region over the next sort of few years is showing that this approach works. Like, give us a lot of flexibility, tell us what you're worried about, and we'll fix it. Because sort of the alternative is if the commission looks at it 2 or 3 years down the road and it's been a complete, fiasco in implementation and people are fighting about, how compliance needs to be monitored and enforced, then the alternative is for the commission to crack down and say, we're going to go as far as we can under our jurisdiction, and we're going to demand a lot of really specific things, and hopefully we're on the path to avoid that.
Thanks to our friends from FERC in the room.
That's right. So on the implementation phase, these are the things that I sort of think will be the main challenge. The first one is bringing your procurement folks into compliance. Traditionally, procurement, their interaction with NERC is often to sort of have some standard NERC terms and conditions related to like employee access issues. And here we're actually talking about regulation of their process and having a procurement process that'll spit out auditable documentation and information. Exactly how that's going to work and, the processes to put in place to accomplish that will be interesting to see. Of course, developing the actual risk management plan itself will be the biggest challenge for implementation. As Paul talked about, identifying your actual forthcoming contracts that you're going to have to worry about, right? So, the first piece there, of course, is to figure out what is the universe of contracts where we're receiving products and services for BES cyber systems. I think that's going to be, probably harder in practice than it sort of sounds like it ought to be in theory. And then once you identify those contracts, you have to look at, okay, what is it that's about to terminate, so that we're going to have to implement this immediately, what's under an evergreen master services agreement, so we probably don't have to worry about it in the near term. And if we have a contract that looks like we're going to have to make some changes to, is that going to trigger, SIP 13 compliance processes for the revision of that contract? You'll also have capital investment issues, particularly not for SIP 13, but for the SIP 5 requirement. That's a technological control to be able to identify and then sort of instantaneously cut off problematic remote access. That's, again, probably easier said than done. And, we've got 18 months, and it's probably going to take that 18 months to, get the budget authority at your utility, go out and find someone who can provide a service and then implement it and have it up and running by July 1st of 2020. And then, I think one of the kind of understated challenges of the standard is the vendor transition issue. So part of what's in SIP 13 or 1.1 is to deal with the supply chain cybersecurity risk created by transition between vendors, and exactly what that'll look like and how you're going to be able to come up with auditable documentation that you had a sort of secure handover from one vendor to another will be difficult, particularly because, in my experience, vendors who know that they're at the end of their contract and it's not going to be renewed and there's no more money coming from your utility are not going to be nearly as interested in cooperating with you as the new vendor who's coming in and is excited about the fact that he's going to have, 5 or 10 years of a revenue stream. when it comes to actually negotiating the contract terms with the vendors, I think there are several provisions. A lot of these we've actually hit on. That'll be, a real challenge. The first one being the confidentiality issues. Part of what vendors will have to do is, provide notification of certain risks that they've identified. And of course, vendors typically don't like to have to do that. They're particularly going to be concerned that in order for you to demonstrate compliance, you'll have to be able to show your regional entity, hey, here are all of the vendor failures and risks that we've identified and that they provided to us, and now you can see them, and here's an explanation of how whoever your vendor is has a number of supply chain cybersecurity issues. Convincing the vendor that the confidentiality provision should allow that, I think will be interesting. We'll have to see how that plays out. The audit provisions, we've got, the possibility of being able to go into your vendor and say, you agreed to a whole bunch of cybersecurity controls. We want to have certain rights to be able to check to see if you're actually doing those things in practice. Traditionally, that's either it's really just been sort of a self-certification or nothing at all, right? Unless something goes wrong, and then you come in and you've got a big fight about it. But, I think one of the best practices that EEI is looking at is having some ability to audit your vendors and, getting vendors to agree to that, and exactly what shape that takes could be interesting. Indemnification will also be kind of a weird one, and I think this is because of how the standard is set up. So vendor noncompliance isn't creating noncompliance. Vendor noncompliance under the contract doesn't create regulatory noncompliance. So, but at the same time, you have to fix things when, vendors make mistakes, particularly if it is a security concern. And so, typically those contracts will have some sort of indemnification provision in them, and coming up with what that should be, what are the thresholds for activating it, what's the maximum liability for a vendor. I mean, these are standard procurement terms, but one of the interesting things here is that, for SIP 13, vendor noncompliance isn't going to, cause you to be fined, but at the same time, vendor noncompliance under, for instance, SIP 4, right? So somebody messes up your traditional day-to-day access control, that is absolutely going to result in noncompliance for a utility. And so looking at all those things and how they interplay should be interesting.
Hey, Dan, just to mention, one of the things that we're looking at, particularly on our larger real-time system procurements, is security performance payments. So basically withholding some incentive payments, if they can demonstrate. So not relying more on the carrot than the stick, particularly in unregulated areas.
Of course, the expense issue, right? You're going to ask for a lot of things. The vendor's not going to provide any of those things for free and say, oh, we're going to offer you the service for $1 million. You now want all these additional security controls. Your price is still $1 million, right? That's not how it's going to play out. But they're going to come back to you with something, right? They'll say, well, we'll do that, but it's going to be another 10%, or it's going to be another $50,000, and that's going to put companies, I think, in an interesting position. Because there's some level at which I think it's a compliance culture problem. They say, hey, it's going to cost a tiny bit more, but you don't want to go there. But at the same time, if they, they're going to try to hold you hostage and say it's going to cost some massive amount, then obviously in the standard, you're not required to accomplish all of these things in your actual contract language. And so finding that right balance will be interesting. Obviously, companies will want to standardize as much of this with as many vendors as possible because if you're a large company, in particular, you're going to probably have an enormous number of vendors where you need to manage these issues. You don't want to have bespoke supply chain cybersecurity requirements for each and every vendor because then it just becomes simply unmanageable for your procurement folks. And then, obviously, the subcontractor issue, which we talked about before, and how you're going to deal with that. From a compliance perspective, what I think will be interesting is how all of this flexibility is really going to work when the folks from FERC, NERC, or the regions show up for an audit or spot check, and what really they're going to require you to demonstrate and show documentation of. So one of the issues is, under R2, you have to implement your supply chain management program, but you don't have to renegotiate or abrogate existing contracts, right? That doesn't mean that those contracts are simply, those vendor relationships are outside the scope of the standard. What it means is that you're going to have to demonstrate something for those entities that sort of, here's kind of what we could accomplish. And, understanding, in fact, I think for a lot of this, hopefully, some of the NERC guidance to be developed over time, some of the regional entity guidance to be developed over time will kind of give people a better idea of what exactly they're going to need to produce. The issue of, vendors refusing to agree to some of the actions, and, what are you going to show during an audit to say, okay, we tried to accomplish our plan, we tried to negotiate it, and the vendor said no, right? Are you going to have to open your books on those negotiations and show those prices that, the vendor came back to you with, or, what the vendor said? I mean, a lot of times that would be covered by some incredibly strict confidentiality provisions that may or may not, give you the discretion to say, hey, come in and look at all of the financial information we got from our outside vendor. And, so exactly what you'll need to be able to demonstrate in those circumstances will be interesting.
Yeah, one thing to consider in that regard is redaction of certain terms and conditions, right? You can think about what you can show, what you can't, and what you need to redact when the auditors come on site.
And so I think this is one of those cases where this could absolutely work out really well and drive great cybersecurity practices, that protects the bulk electric system. It could also end up with a lot of fighting between utilities and their auditors, which is sort of bad for everybody. But, hopefully this implementation period and all this guidance allows us to get to a better place. And then finally, I think Paul and Jamie both hinted at this. One of the big opportunities that this provides is everybody's going to have to look at a lot of their outside vendor relationships again, and this provides a great opportunity to say, we've got a lot of contracts with a lot of people, right? Rather than just doing SIP 13, let's take a look at sort of cybersecurity stuff generally related to these contracts and say, what can we do that's not just, bare minimum SIP 13, but what actually puts all these vendor relationships on a good cybersecurity footing, right? You might have things that were, master service agreement from 2008, right? That's not going to deal in a meaningful way with software as a service. But, a 2018, 2019, master service agreement presumably would. This is a good opportunity to make sure your MSAs actually make sense, as we get into 2020, right? SIP 4 issues, right? This is a constant source of vendor-created noncompliance. It's a good opportunity to take a look at your vendor agreements and see if you can tighten up, some of the risk areas there for vendors getting access physically and electronically to the cyber systems. It's an opportunity to look at your vendor side, cybersecurity more generally. So, for example, you not only have to worry about your own cybersecurity of your own network, but you want your vendors to have sort of good cybersecurity hygiene. And even though this isn't required by the language of the standard, you're in a better place from a security perspective if you know your vendor isn't sort of just doing what it needs to meet SIP 13 for you, but is in fact, implementing the NIST framework in a meaningful way so that it achieves its own cybersecurity. Because, if your utility is at the center of sort of a whole bunch of vendor relationships, you also benefit from a kind of herd immunity. If, all of your vendors have really good cybersecurity hygiene, it makes it much less likely that you're going to experience some of the cybersecurity issues and breaches that kind of tend to make the news. And then, finally, I think one of the issues is whenever there's vendor issues that create either non-compliance or just some other cybersecurity breach, a lot of existing contracts don't do a great job of explaining how the vendor and, the utility are actually going to work together to remediate that and fix it and to deal with the cost responsibility for fixing it, providing notifications that might be required under state law, providing, dealing with federal or state investigations resulting from that. And so it, provides an opportunity to look at that, see what your existing agreements have, and try to fix those issues as well.
Thanks, Dan. So we're a little bit over time. I do want to leave a few minutes for questions in the room and on the phone, but just before we go there, I hope what you've heard from the three panelists is, this is a standard that's not your typical NERC standard where just NERC specialists work on it. It's cross-cutting, it's cross-practice. It's a place where you should be engaging in-house counsel, possibly in multiple areas. It's a place where you should be looking at regulatory resources for support if you're confused. It's also a place where outside counsel can leverage their relationships with their clients to start having conversations about SIT 13. Ask your clients, have you thought about this? What are your current plans? Where are you heading? This date's coming up. At Exelon, we've been working for this over a year, maybe a little bit more. And even outside of the supply chain standard, Paul's been working on this as just a general good business practice to increase security. So there are opportunities here for attorneys to play a large role in driving better cybersecurity. So see this as an opportunity for yourselves as well to get in the game. And with that, we'll open up to questions and any last comments. Anybody here on the phone?
Hi, Bill. This is Andrea Chambers. How are you? It's been a great presentation. I just had a quick question, and I don't know, I have also had to go to a few things during this, but what I was trying to find out is I've gotten calls from vendors, and, they get these certifications handed to them that say you will comply with NERC substandards, and they have no idea what is being talked about. Is there, has there been any, are utilities required to post anything on their website or anything that they can share with the vendors about what they're expecting them to comply with?
Yeah, and obviously the requirement is set up for the registered entities to comply. So looking at the standard itself will tell you the areas that the vendors, if they look at the standard, will tell you the areas that the clients or the companies are going to need to shore up. But the
standards are all written in terms of what the registered entities have to do, right?
Exactly. What they're going to see, basically the company should be reaching out to the vendor either through their modifications to their contracts or direct communications to address these areas. One resource that I mentioned, the EEI's project, is going to have these model terms and conditions, and they're going to be pretty straightforward. Has the vendor implemented internal policies and procedures that would allow them to achieve each of these requirements, and is there a mechanism for notice, and are there basic expectations set up? So I think once that comes out, we're hoping over the year or so before implementation, that'll spur discussions back and forth between the vendors and companies. But that's my thoughts.
Okay. Some of them are being asked to sign on now. That's what.
Yeah.
So I've done a legal opinion already for one vendor, but I was just wondering if there was anything that was going to come out to be more educational.
I don't think directly to that. I guess the other thing to think about is the line, what's sort of supply chain driven and what's driven by the rest of the existing SIP standards. So you might have vendors who have to comply with that type of language because they're being onboarded and given direct access to BES cyber systems or information just like a company employee would. in which case there's, direct impacts from a compliance standpoint for the entity. So, I think that's something else that the lawyers can help tease out is which NERC standards are we talking about? Are we talking about the ones where we're basically behaving on your behalf, or are we talking about a standard like the supply chain one where there's a process being applied to us where we're being expected to sort of meet a general behavior pattern but may not have any direct compliance responsibilities as a vendor?
Andrew, it's a really good point, though. It would be nice to have a, what does this mean for me type of publication. And something.
I mean, it's very scary for people that get handed a certificate saying, I swear that I've complied with all the NERC standards, and you look at the NERC standards and they really don't apply to them directly.
That's not probably the best way to handle it.
No.
Yeah.
Good question. Any other questions on the phone or in the room? Any last thoughts from our presenters? Otherwise, I think we're wrapped. Thank you again to Morgan Lewis for hosting us, and thank you all for your time and attention, and we hope you enjoy the rest of your afternoon. Thank you very much.
Thank you.